This is People of the State of Michigan versus Jeremiah Finley, docket number 20-318FC. This is the time set for sentencing. Mr. Finley, you were convicted of child sexually abusive material, a felony punishable by up to 20 years in prison, and second-degree criminal sexual conduct, a felony punishable by up to 15 years in prison. You have the right to be represented by an attorney. You are represented by Mr. Watson. And Mr. Finley, can you just confirm for me that you are agreeable with us doing this sentence with you in the jail instead of in the courtroom in person? That's okay with you?
Yes, ma'am, it is.
All right, thank you. And Mr. Watson, have you had a chance to go through the pre-sentence report with your client?
Yes, I did, Your Honor. I believe it was last Friday we reviewed that together. I have my investigator present with me as well.
And do you have any additions, deletions, or corrections?
Turning to the pre-sentence investigation report on the first page toward the bottom, it indicates that my client denies that he's had mental health treatment. Mr. Finley advises that he was never asked that, and because I don't believe that he would have denied that he's had mental health treatment.
You mean on the face sheet?
Yes, Your Honor.
Well, it says psychiatric history. Is that what you're talking about?
Yes.
So you want me to change that to yes?
Please.
Okay. Also, I've done that. And then also, while we're on the face sheet, under current convictions, it says bond posted, and I put not posted.
Right. Thank you.
Okay. Your next change, Mr. Watson?
There are no other changes to the body of the report and its sections. Only other change have to do with the basic information report. It indicates that, or under the heading education, it indicates that my client has no GED that was accurate at the time of the writing. It is no longer accurate. Mr. Finley reports that he's now obtained his GED.
Okay. Well, I think I'll leave it as of the writing, because I think if I change it, they would have asked for verification, and
Sure.
Since I don't have that, I'm just going to leave it as of the date of the writing. He did not.
Very, very fine.
And anything else?
No other changes to the body of the report. I have discussed with Ms. Eisenhut a particular change in the sentencing information report. I'll let her address that. But having reviewed that offense variable and its scoring that she requests, I won't have any objection to it. It does not affect the guideline range.
Okay, and Ms. Eisenhut, first of all, did the people have any other additions, deletions, or corrections to the report itself?
Not to the report, thank you, Your Honor.
Okay, and now you had a correction to the guidelines?
I did. I actually have two corrections. I had spoken with Mr. Watson earlier about my first one. Neither changed the range of the guidelines. The first one is OV8. This is the one we did discuss. It's scored at 0 currently. It should be properly scored at 15. The facts of this case indicate that the victim was picked up from her parents' home and transported to a park where the sexual assault occurred.
Okay, and Mr. Watson already said he has no objection to these changes, so I've changed OV8 to 15.
That was the one that we discussed, Your Honor. I have my guideline book before me now to address the other.
Okay.
I can review it at the time that it's expressed.
Thank you, Your Honor. OV12 is currently scored at 0. The people would request that it be scored at 5 for one additional crime against a person that occurred within 24 hours. The basis of that scoring, Your Honor, would be that there was a dismissed count of using a computer to commit a crime that would have occurred alongside of the child sexually explicit material count. Therefore, making that count 5 points instead of 0. The total OVs would be 70, and again, the guidelines would not change.
Okay, Mr. Watson, let me just verify, because your audio's not very good, but you're in agreement with that change as well?
I'm looking at OV12 now, and it's scoring for one contemporaneous felonious criminal act involving a crime against a person. And, sorry, I just need a second to review the instruction.
Right, go ahead.
Well, considering the dismissed count, and as Ms. Eisenhut has placed it on the record, the dismissed count being that offense, and considering the fact that it would not affect the guideline range, I would have no objection then to 5 points on OV 12.
Okay, so I've changed that as well, and as the prosecutors indicated, the total OVs are 70, so it's still at a level C5, guideline range of 51 to 85 months. There's a Killebrew agreement of 84 months fixed on the minimum sentence, so it doesn't change the guidelines, and it also is sort of irrelevant in the face of the Killebrew agreement, but I did make the changes regardless. Ms. Eisenhut, was there a victim or someone on behalf of the victim that wanted to be heard on this case?
Your Honor, the victim and her parents do not wish to speak today.
Okay, and then did the people wish to be heard?
Yes, thank you, Your Honor. I have consulted with the victim and her parents multiple times prior to this date. This plea is a result of those discussions and acknowledges the circumstances in this case, including the predatory conduct undertaken by Mr. Finley. We would ask that the court follow the Killebrew agreement and sentence Mr. Finley to a fixed minimum of 84 months on both counts. Thank you, Your Honor.
Thank you. Mr. Watson?
Thank you, Your Honor. I can tell you that this young man is quite remorseful for the conduct in which he engaged. He's expressed that multiple times. Frankly, he's expressed it in letters that he's drafted to the court, which I don't know have been reviewed or not. I know that there was one letter that was reviewed recently. Mr. Finley requested the opportunity for essentially a furlough to visit the child whom he refers to as his son, who he has a parent-child relationship with. But I know that there have been other letters that have been sent to the courts, both at the district court and at the circuit court level. And frankly, even in those letters, he's expressed his remorse for his very poor judgment, his very bad thinking concerning this. I don't know that Mr. Finley necessarily recognized at the time that he was committing these offenses how very serious these offenses were until he became charged. He made various offers as far as settlement is concerned. Some of them I perceive to have been based on mental illness, quite frankly, and that was part of the reason for the delay in this case, is that there had to be a competency evaluation to be made of him based on some of the things that he had to say. I can tell you, though, that after many consultations with him, I'm advised and I believe that he now takes very, very seriously the offenses that occurred. The fact that he offered his plea in this case, I think, was his attempt to, in some way, to try to make it so that the victim in this case was not somebody who was re-victimized during the course of a case, during the course of a trial, to spare the family this. I can recognize as well that that he feels that that this is a sentence that he can agree with. Frankly, this Killebrew arrangement, this final agreement that we entered into, was at his request, and people did accept that, and that's why it is he offered his plea.
I couldn't hear any of that. I heard request and then nothing after that.
Okay, well, Your Honor, I'm afraid I'd forgotten what it is I'd said here, but beyond the word request. But I can tell you that this plea agreement was something that was negotiated back and forth and ultimately resulted in this at Mr. Finley's request. Mr. Finley is prepared to accept a sentence, and I would hope that Your Honor, based on all of this, accept the Killebrew agreement and sentence in accordance with that. Thank you.
Thank you. And now, Mr. Finley, is there anything you wanted to say?
Yes, ma'am, there is. I have written something to say, if that's okay to read.
It is. Just keep your voice up, please. You're doing well, but remember to keep your voice up because we're recording and then we're redoing this remotely as well. Go ahead.
Yes, ma'am. I would like to say with my heart that I am deeply sorry for my actions. You can ask anybody that knows me. I'm not usually like this and act that way that I did. I do not like to cause any harm to anybody in any way, especially to women or young ladies. So when these incidents happen over the course of the latter time frame, I am greatly ashamed of myself since I made it happen. I want to send out my deepest heartfelt apology to the victim and her family for all the harm, displacement, hardship, and mental as well as physical anguish that I may have caused by my doings and actions, for they were wrong and poorly chosen, causing me to make a bad decision that I now live with every day and will for the rest of my life. With my ill-chosen decision that I have made that has landed me here in ICJ, I have took it upon myself to start the renewing and transforming process by getting my GED, getting my certificate while I worked in the kitchen, went through anger management and got my completion certificate. I voluntarily placed myself in CATS, sponsored by CMH, and doing CBT classes, as well as one-on-one therapy sessions with my counselor, also trying to better myself as a Christian man by doing self-study Bible studies sponsored by the chaplain here in ICJ. I also know that every action has a reaction, and my choices have affected her dearly, so I have wanted to put out there that if she requires hospitalization, therapeutic services due to the traumatization I have caused her, I will do everything I can to pay back the cost of the bill to the family, just as a start of trying to make amends for my wrongdoings I have done to her and her family. So I also know every action has consequences, and I'm willing to and ready to take full responsibility and face the consequences for my actions, because this is all my fault in every way and not hers. May God have mercy on me.
All right, thank you. Well, Mr. Finley, I'm glad to hear you say that this is all your fault and not hers. I hope she's listening or has a chance to know that you said that. It's extremely important, and I see, many signs of you truly accepting your responsibility and owning up to this. I just have to comment, though, on a couple of places where I thought that you were backsliding on that. You said in the pre-sentence report that it says that you said you don't know how it affected the victim and thinks her family feels frustrated because it looks like a grown man took advantage of their daughter. And you also told me that you're sorry for any mental anguish and harm you may have caused. I just want to reiterate, and again, you've said some good things and they show responsibility and acknowledgement, but I want to reiterate that to her family, it doesn't look like a grown man took advantage of their daughter. A grown man did take advantage of their daughter. And it's not that you may have caused her mental anguish, you did cause her mental anguish. I just think we have to be crystal clear on all of that. I know you're still relatively young, but under the law, you are an adult and you are a grown man. And while you still have some maturity to reach, you knew better, and it was on you not to let this happen. So in the pre-sentence report, where you say it was the victim's idea to start talking and her idea to meet up, I say, let me be 100% clear to you, it does not matter. It's on you. She didn't do this, but let's just say a 12-year-old ripped off all of her clothes and jumped on top of you. That's not her fault, and that's not her initiating anything. You're the adult. It's up to you to exercise responsibility. And as a result of you not doing this in this case, you have harmed her. You've harmed her greatly. And it sounds like she is in a lot of pain and suffering and will take a long time to work through this. You're fortunate that you don't have to deal with it in the same way that she has to deal with it, although I do acknowledge that this agreement that you willingly made about your plea and your sentence does at least acknowledge that you have a price to pay as far as incarceration goes. And I think it's justified. So I am ordering that you pay $130 to the Crime Victims Fund, $136 in state costs. I'm assessing costs in the amount of $250 based on the State Court Administrative Office calculated average cost of a criminal case in Ingham County. That's actually a very drastic reduction that I made from that average cost. And on count 2, you are sentenced to the custody of the Michigan Department of Corrections for a period not less than 84 months, nor more than 240 months. You receive credit for 300 days already served. On count 8, you're sentenced to the custody of the Michigan Department of Corrections for a period not less than 84 months, nor more than 180 months. You receive credit for 300 days already served. Those sentences run concurrently or at the same time with each other, and you are also required to comply with lifetime electronic monitoring. Mr. Finley, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. We will mail the form to you that tells more about that. You should just be aware that any appeal period starts running from today's date, and it's 42 days. So we will send that out to you. Do you have any questions before we leave?